I have always found it to be the pinnacle of judicial irony that the judge who is called upon to determine whether or not a judge should be recused from a file is that judge themselves. Viva Frei, Montreal litigator turned YouTuber, and it is vlog time. Now, I'm not going to use the living under a stone analogy because this is not necessarily common knowledge, but for those of you who don't know, Roger Stone was recently found guilty on 5 charges of lying to Congress, 1 charge of witness tampering, whatever, and he was sentenced to 4 years in jail. I've done a couple of videos on Roger Stone already, the first of which broke down the convictions. I'll link that video right here. The second vlog I did on the subject pertained to one of the 12 jury members who outed herself after the trial in protest to the 4 prosecutors who withdrew from the file after the Department of Justice overturned their recommendations for sentencing for Roger Stone. There's a lot to unpack in there, and I'm taking for granted that you have watched those 2 previous vlogs before watching this one. In that vlog, we talked about the jury member who outed herself and in so doing revealed her, let's just call it suspected partiality against Roger Stone and the Trump administration in general. And then as a follow-up to that, I did another live stream with attorney Robert Barnes, who graced me with his presence and his knowledge, and we talked about the Roger Stone situation in great detail. I will link that live stream right here. I'm going to make a Roger Stone playlist, which I will link at the end of this video and put in the comment section below. And this brings us to the subject matter of the present vlog, which is Roger Stone's attorneys making a motion to the judge Amy Jackson to recuse herself from the file for an apparent lack of partiality as relates to Roger Stone. This particular motion, in case you're wondering why I'm pointing, it's because I'm pointing at my computer, is called a motion for judicial disqualification. In my jurisdiction, it's called a motion for recusal. The idea is that the petitioning party makes a motion to the judge to recuse his or herself from the file on the basis that the judge lacks the requisite impartiality in order to judge the parties fairly. How many of these motions have I presented in my 13+ years as a commercial litigation? Absolutely none. I have never presented one because they're virtually impossible to succeed on. In fact, the only judge who would grant such a motion in the first place would, in all likelihood, recuse his or herself by their own volition. And this is ultimately sort of the sick comedic judicial irony in all of this. The motion to recuse itself is presented to and to be adjudicated by the very judge who you are asking to recuse his or herself from the file. It is really nothing more than a case of we have investigated ourselves and concluded no wrongdoing. Roger Stone was found guilty after a trial by jury of 7 charges. 5 charges of lying to Congress, 1 charge of witness tampering, and another charge of obstruction of proceedings. After Roger Stone was convicted, the prosecuting attorneys indicated that they were going to go after a sentencing of something like 9 years for those convictions. People were outraged, or at least some people were outraged at what appeared to be rather excessive sentencing that the prosecution was going after. Some of those people were Trump's Department of Justice, who proceeded to override the recommendation from the prosecuting attorneys of going after 9 years in jail. After the Department of Justice intervened, 4 of the prosecuting attorneys in the Stone file withdrew from the case. And one of the jury members, who was also the jury forewoman, went on CNN to give an interview to stand in protest with the 4 prosecutors who withdrew from the file. In so going on CNN, she revealed her identity, and the internet being what it is, people quickly looked through her social media footprint and found radically anti-Trump and anti-Roger Stone tweets and social media posts. And from there, all heck broke loose. People started wondering if this jury forewoman had lied on her questionnaire in order to get onto the jury. Others were questioning whether or not Judge Amy Jackson knew of this apparent tainted jury member. And others began to question the gag order that Judge Jackson had imposed in the file and whether or not it was intended to hide the fact that at least 1 and possibly more of the jury members were in fact tainted jury members. After the Department of Justice intervened, Judge Amy Jackson sentenced Roger Stone to 4 years in jail. Roger Stone filed a motion for a new trial. That motion has yet to be heard, and in the interim also filed a motion for judicial disqualification of Amy Jackson from this file. That is the context. Now let's read the motion. Defendant Roger Stone's motion for judicial disqualification. Argument. The issue at hand arises from the defendant's pending motion for a new trial and statements made by Judge Berman Jackson during the defendant's sentencing hearing on February 20, 2020. That's a lot of 20s. Some might even say that this year is the year of hindsight. Stone's argument for a new trial rests on newly discovered information indicating that there was juror misconduct during Mr. Stone's trial, thereby depriving him of his constitutional right to be tried by an impartial jury. Defendant's motion has not been ruled on, and in fact the defendant's reply to the government's opposition is not yet due, nor has a hearing been set. The court must still consider whether any juror interviews are appropriate in light of the allegations. However, given the statements made by Judge Berman Jackson during the sentencing hearing, recusal under 28 U.S.C. 445A is warranted in order to protect the integrity and impartiality of the judicial system.
Sorry, I ran out of breath towards the end of that sentence.
That was the factual context, and now we get into the law. 28 U.S.C. 445A states, any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceedings in which his impartiality might reasonably be questioned. A showing or appearance of bias or prejudice sufficient to permit the average citizen reasonably to question a judge's impartiality is all that must be demonstrated to compel recusal. The goal of Section 445 is to, quote, avoid even the appearance of partiality. In addressing the mere appearance of partiality, Section 455 addresses not only fairness to the litigants, but also the public's confidence in the judiciary, which may be irreparably harmed if a case is allowed to proceed before a judge who appears to be tainted. It has been argued that any public comment by a judge concerning the facts, applicable law, or merits of a case that is sub judice in his court, or any comment concerning the parties or their attorneys, would raise grave doubts about the judge's objectivity and his willingness to reserve judgment until the close of the proceedings. Disqualification under Section 455A is appropriate even after a final judgment is entered in certain situations. And yes, I mispronounced it. It's pronounced sub judice, and what that means is something that is being studied or adjudicated upon in a court of law at the present time. Stone's motion for new trial is directly related to the integrity of a juror. It is alleged that a juror misled the court regarding her ability to be unbiased and fair, and the juror attempted to cover up evidence that would directly contradict her false claims of impartiality. Nevertheless, at Mr. Stone's sentencing, the court emphatically stated its views regarding both of the defendant and the jurors in his trial. Everyone depends on our elected representatives to protect our elections from foreign interference based on the facts. No one knows where the threat is going to come from next time or whose side they're going to be on. And for that reason, the dismay and disgust at the defendant's belligerence should transcend party. The dismay and the disgust at the attempts by others to defend his actions as just business as usual in our polarized climate should transcend party. The dismay and the disgust with any attempts to interfere with the efforts of prosecutors and members of the judiciary to fulfill their duty should transcend party. Sure, the defense is free to say, so what? Who cares? But I'll say this, Congress cared. The United States Department of Justice and the United States Attorney's Office for the District of Columbia that prosecuted the case and is still prosecuting the case cared. The jurors who served with integrity under difficult circumstances cared. The American people cared, and I care. And this is where we get into the crux of the motion for judicial disqualification. Recusal is required based on the entirety of the above, and this statement in particular. Quote, the jurors who served with integrity under difficult circumstances cared. Whether the subject juror, or perhaps others, served with, quote, integrity is one of the paramount questions presented in the pending motion. The court's ardent conclusion of integrity indicates an inability to reserve judgment on an issue which is yet to be heard. Moreover, the categorical finding of integrity made before hearing the fact is likely to, quote, lead a reasonably informed observer to question the district judge's impartiality. Public confidence in the integrity and impartiality of the judiciary is seriously jeopardized when judges share their thoughts about the merits of pending cases. The premature blessing of the, quote, integrity of the jury undermines the appearance of impartiality and presents a strong bias for recusal. Now, at its base, it is a simple argument, but it is very compelling. There is a motion for a new trial that is pending before this very judge. One of the core questions of that motion is whether or not the jury was in fact tainted, or at least one member of the jury, possibly others. If a jury member was in fact biased, was in fact tainted, did in fact lie on the questionnaire in order to get on the jury, it would compromise the alleged integrity of that jury member. And so the judge, by making this statement in advance of hearing the actual motion for a new trial, which calls into question the integrity of at least one of the jurors, is sort of coming to a certain conclusion as relates to all of those jurors. That's the argument, and there are going to be compelling reasons for it, but there are also going to be compelling reasons against it. First and foremost of which, and it doesn't actually come up in Judge Amy Jackson's judgment, but apparently thanking the jury for their integrity is par for the course in every single trial by jury. Some are going to say that it's absolutely standard, others are going to say that until proof to the contrary, it is basically accepted protocol. And that in thanking the jury for their integrity during hard times, the judge is not actually coming to any conclusions, it's just common courtroom parlance, so to speak. That is one argument against Roger Stone's motion for judicial disqualification, but let's actually just read through Amy Jackson's judgment. Order. Defendant Roger J. Stone has filed a motion seeking the court's disqualification pursuant to 28 U.S.C. 455A. In assessing Section 455A motions, the D.C. Circuit has applied an objective standard. Recusal is required when a reasonable and informed observer would question the judge's impartiality. This standard requires that the court take the perspective of a fully informed third-party observer who understands all the relevant facts and has examined the record and the law. From this viewpoint, quote, bald allegations of bias or prejudice do not suffice. The defense does not argue that the jurors did not, quote, serve under difficult circumstances, but it complains that the court's use of the words, quote, with integrity are disqualifying because there is a pending motion for a new trial with respect to a single juror, and the hearing has not yet taken place. There are several reasons why recusal is not warranted. Now, I've got to point out something that drives me crazy when I read these judgments. It's the third-party way in which the judge is describing everything. The judge is referring to the court having said something when it's her having said something. The sentence, "There are several reasons why recusal is not warranted," is drafted in the passive sense, and that drives me nuts. Properly drafted and properly read, the sentence should say, "There are many reasons why I am not recusing myself from this file." But in drafting it in the passive third-party sense, the judge sort of like removes herself from the equation and makes it all about the court. Incidentally, this is not a critique or an accusation against Judge Jackson in particular. This is the way the courts do it. It's just so frustrating to read. Oftentimes, these court orders are drafted in such a way so as to remove the actual individual who's making the decision. It's done sort of to depersonalize the judgment, as though there's not an individual human behind it, it's just the machine doing it. Alright, tangent over. First of all, the court did not make any, quote, finding about the pending motion for a new trial, much less a, quote, categorical one. The motion raises questions concerning the completeness of one of the jury's responses during the jury selection process, and it speculates about exposure to prejudicial extra-record material during deliberations. But it does not include any allegations or set out any facts impugning the integrity of any other juror or jurors. The court's very general comment that, quote, jurors served with integrity, 3 words on the 88th page of the 96-page transcript of a 2.5-hour hearing, did not purport to and did not address the motion. Agree or disagree with what's being drafted here, I do want to point out something kind of interesting. The judge points out that the motion does not include allegations impugning the integrity of any other juror, which is all fine and well, but kind of immaterial in that it implicitly recognizes that the motion does impugn the integrity of at least one juror. In which case, what Judge Jackson said about all of the jurors might be all the more relevant in that it includes the one impugned juror that is included in Roger Stone's motion. And the fact that it's only 3 words on the 88th page of a 96-page transcript of a 2.5-hour hearing doesn't really mean all that much to me. The fact that it's only 3 words doesn't necessarily undermine the substance of the argument. Imagine those 3 words were, "I hate you." I don't care if that's only 3 words of a 1,000-page transcript. If a judge ever says to one of the parties, "I hate you," that might be enough to warrant recusal, in my humble opinion. So what is not determinate is that it's any minimal number of words on any maximal number page transcript. It's what those words were and what impression they might create in the eyes of a reasonably informed general public. "I hate you," just 3 words. "Go to hell," just 3 words. "Drop dead now," just 3 words. 3 measly little words that can cause someone to question the partiality of the judge who uttered them. Now, I am not building a strawman argument, and there is no but to that. What I am doing is a reductio ad absurdum. The fact that it's only 3 words is irrelevant. It matters what those 3 words were. Taking the most extreme absurd example, 3 words can make a difference. Second, to the extent that the court made a statement about the jurors that could be perceived as relating in some way to an issue raised by the pending motion, it was not the, quote, extrajudicial statement that is needed to support a motion such as the one filed in this case. The Supreme Court has made it quite clear that to be disqualifying, quote, "the alleged bias and prejudice must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in the case." Now, this is a very interesting distinction in law that is going to lose its impact a little bit later in the order because of other things that are said later on. But the idea here is that in order to be disqualifying, these statements have to be made in an extrajudicial context. If Judge Jackson had previously said prior to becoming the judge in this file that Roger Stone is a pathological liar, that would be an extrajudicial statement that might compromise anyone's ability to perceive Judge Jackson as being partial, at least as relates to her ability to act as an impartial judge in the context of a Roger Stone trial. But the situation would be different if the judge were to qualify Roger Stone as a pathological liar after having heard all of the evidence in trial. There you would have a situation of the judge coming to certain conclusions based on the evidence that was adduced during the trial, as opposed to having come to predetermined conclusions before the trial even started in the absence of any evidence. That is the distinction between extrajudicial statements and statements made in the context of court in the context of the trial. You've been in the house the whole time, haven't you? This is so embarrassing.
What are you talking about for so long? It's lunchtime.
Right, I'll be done in 5 minutes. Judge Jackson undermines the impact of this argument based on the extrajudicial statements later on in the same paragraph. Indeed, she goes on to acknowledge that it's not just on the basis of extrajudicial comments that a judge can be forced to recuse themselves. Therefore, quote, "opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings do not constitute a basis for a bias or partiality motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible." The court stressed in Liddicky that, quote, "recusal is required only if the judge's impartiality might reasonably be questioned." And it concluded that, quote, "to demand the sort of childlike innocence that elimination of the extrajudicial source limitation will require is not reasonable." In other words, judges cannot be, quote, "biased and need not be disqualified if the views they express are based on what they learned while doing the job they were appointed to do." Judge Jackson then goes on to distinguish the current situation from the case law cited by Roger Stone in support of his motion, as do all judges when they want to come to a different conclusion. I'll put up a screenshot of that justification right now so that you can give it a read while listening to the soothing, relaxing tone of my voice in the background. Judge Jackson then goes on to state that the court's impartiality has not been called into question as a result of extrajudicial comments, as though that were the only issue. The comment does not begin to suggest that the court's impartiality has been compromised by extra record information, or that the appearance of impartiality has been undermined by extrajudicial pronouncements. My humble opinion is that this is something of a mischaracterization of the question at issue. Roger Stone was never alleging that it's on the basis of extrajudicial comments that the judge should recuse herself. On the contrary, Roger Stone is suggesting that the judge should be forced to recuse herself on the basis of statements she made in court, which show a certain bias or partiality in the eyes of a reasonable person. The judge, in an attempt to show how fair the court has been with Roger Stone, then goes through an inventory of examples where the court was in fact fair with Roger Stone. Moreover, the record dating back to January of 2019 reflects that the court took each issue raised by this defendant seriously, that on each occasion it ruled with care and impartiality, laying out its reasoning in detail, and that it was scrupulous about ensuring his right to a fair trial. It granted important evidentiary motions in his favor. It proposed utilizing a written questionnaire to ensure that the parties could receive more information than is usually available for jury selection. It struck 58 potential jurors for cause based on the defendant's motion or on its own motion. And it repeatedly resolved bond issues in his favor even after he took to social media to intimidate the court, after he violated conditions imposed by the court, after he was convicted at trial, and after he was sentenced to a term of incarceration. Moreover, at the sentencing hearing that forms the sole basis for the defendant's motion, the court concluded, based in part on many considerations put forth by the defendant, that it was appropriate to vary from the applicable advisory sentencing guideline range. And again, just thinking critically, reading this judgment on its face, it seems that what the judge is doing here is raising past examples where she believes she acted impartially to undermine the current accusation of bias. And again, just thinking logically, it's not because someone didn't do something wrong in the past that it means they didn't do something wrong in the present. Roger Stone's motion is not calling into question all of the previous decisions rendered in that file. It is calling into question one specific act conducted during the sentencing hearing. Moreover, because I know that a lot of you are probably thinking this, the fact that the judge says that she deviated from the standard sentencing guidelines to evidence her impartiality, some people might say that those sentencing guidelines were inflated from the beginning, and therefore deviating from the inflated sentencing guidelines is not itself an act or evidence of good faith or impartiality. Just throwing that argument out there because I know some of you are thinking it. And then the judge goes on to conclude as follows. There is no rule and no case law that would justify the recusal of a judge for bias simply because he or she says something about an issue on the docket, on the record at some point before a reply has been filed or before a hearing, which may or may not be required in the court's discretion, has concluded. If the parties could move to disqualify every judge who furrows his brow at one side or the other before ruling, the entire court system would come to a standstill. And 5.5 pages later, this I think is the only thing the judge had to say from the get-go. Alright, so the judge praised the integrity of all of the jurors, notwithstanding a motion for a new trial, on the basis that one of the jurors might have concealed her bias. If that were to become the new standard for judicial disqualification, everybody and anybody would ask to disqualify a judge, and the entire judicial system would come to a total standstill. At the bottom, given the absence of any factual or legal support for this motion for disqualification, the pleading appears to be nothing more than an attempt to use the court's docket to disseminate a statement for public consumption that has the words judge and bias in it. For these reasons, defendant's motion is hereby denied. It's very interesting because that last paragraph almost presupposes an intention that could only be divined through bias. Okay. Jokes aside, I do think that last paragraph was rather gratuitous and might come back to haunt the judge. I don't think it's going to be the last time that we are going to hear this paragraph in a court proceeding. The other reality is that I do think Roger Stone had more arguments and more compelling arguments to include in his motion for judicial disqualification. And if I'm his attorneys, I'm reading through this judgment to identify all of the weaknesses in that motion, possibly to amend or file a new motion, possibly also including the last paragraph of this order. All that to say, I don't think Roger Stone is ever going to succeed on this motion. If the bar is lowered, if it becomes a political tool, actually there's something of an analogy here to impeachment, but if that happens, it would paralyze the entire process. Much in the same way lowering the bar for impeachment might actually paralyze the entire government's ability to function. Alright, I hope you got something out of this. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell so you get notifications when I go live or when I post a new video. If you want to support the channel, I've got Patreon, I've got Subscribestar, I've got merch, I've got a PayPal link all in the pinned comment. I appreciate any and all support, but especially sharing my content on social media. And now you know your vlog. Peace out. Booyah!